Okay. Welcome to the third case today in our September 14th, 2020 morning docket. I'll call the case of Elidio Cianez Ocon versus Seaboard Corp. And American Zurich Insurance Company and the Kansas Workers' Compensation Fund. Would the parties state their appearances, please?
Caulfield Sanchez appears for the appellant.
Daniel Estes for Seaboard Corporation and American Zurich Insurance Company.
Okay. All right. And Mr. Sanchez, did you wish to reserve any time for rebuttal?
2 minutes, Your Honor.
2 minutes. Okay. I'd like to introduce the panel members who are here with me today. I'm Judge Karen Arnoldberger, Chief Judge of the Court of Appeals, and I'll be the presiding judge over this panel, which just means I get to keep time, which I generally don't do very well. We also have Judge Stephen Hill, who is now the longest serving judge in the state of Kansas. So lots of experience there, lots of workers' comp stuff Judge Hill has done over the years. And then we also have Judge Gordon Atchison joining us today, who's been on our court for 13 years or so. So we have read your briefs. We've looked at the record in many situations, so you don't need to spend a whole lot of time going over the facts. If I recall, this is a pretty straightforward issue, I think, on time, whether time has lapsed or not. So if we can get right to the issues, please. And with that, Mr. Sanchez, you can begin.
You may please the court. Your Honor, the only two facts that are relevant, and you read the brief, is the time of filing, which was on May 1st, 2015, and occurred at 8 p.m., and the time it was stamped in, which was May 1st of 2015, and the time the notices went out, which was in the brief, which states May 4th of 2015, and it is also in the appeals board decision. Your Honor, the first issue we're here with is the correct date of filing for the application and hearing. Filing application and hearing occurs after 5 p.m., moves to the next day. However, at the time, KAR 5117-2C6 did not state what the next day was. The next day was considered by the appeals board under the same regulation to be May 2nd of 2015, which fell on a Saturday. Our position is the next day should be Monday, May 4th, 2015. As if we look at the appeals board decision, they have the little caption of what was sent out to the attorneys, and the top caption says May 4th, 2015, which is the next business day, the day that the Division of Workers' Compensation was open. As we know, the Division of Workers' Compensation is not open on a Saturday, and it's not open on a Sunday. If we follow the appeals board holding, then to a certain extent, the appeals board at that time or filings prior to 2017 would have all been allowable for Saturday, Sunday, and holiday filings. We believe that's incorrect. The next day isn't defined exactly in the statute, but at a later time, the legislature has stated specifically when they were rolling out Oscar under KSA 44534C after 2017, that explicitly states that Saturdays and Sundays are not to be counted. So in this case, we have the appeals board stating that Saturdays and Sundays can be counted as days of filing. We disagree with that position, and we should hold that the filing of the application for hearing was on May 4th of 2015, and the motion to extend would have been within that 3-year time period. Also, a second issue in this case also stems from what we believe is a conflict between the two statutes as they were written at the time and the time of filing the application for hearing. The appeals board doesn't follow strict construction under KSA 44523F1, as is in conflict with KSA 44534B as written in 2015. 2015. The Court of Appeals usually gives ordinary words or ordinary meaning. Strict construction workers' compensation statutes has usually been the rule since Casco v. Armour Swift 283 Can 605 2007, and the Bergstrom v. Spears warns of judicially created remedies. States basically KSA 44534B states that an application for hearing can be filed within 2 years of the date of last compensation. There are no limitations within KSA 44534B stating that there shall be limited by, stating that there is a limitations of prior filings, nor, which is also important, nor within KSA 44534B is there a reference to 44523F1 stating that you're prohibited from filing a new application for hearing. And is the same as reverse as 44523F1 doesn't state that you are prohibited from any additional filings within this case. It just says dismissed with prejudice, which is also not defined within the Kansas Workers' Compensation Act. We believe that the conflict between these two statutes is resolved only if there's 3 years of unpaid compensation, because that would bring you outside the 2-year limitations of KSA 44534B, and it would also be the 3-year statutory time of KSA 44523F1. And that would basically be 3 years of no compensation paid. The end result of this would be that medical treatment would be provided in a more efficient manner by respondents, that they would stop with medical treatment that's from a very conservative doctor that happened in this case, where they spent 8 or 9 months with a doctor that said there was no knee surgery needed, and another doctor in the future who stated, yes, both knees needed an operation. So that's contrary to respondents' position that the claimants would just extend medical treatment to extend the statute of limitations. As we know in workers' compensation, the respondents have control of who the doctor sees and who is the authorized treating physician. I believe that if the Kansas legislature had wanted to limit the filings of an application for hearing, they had the option to do that in the 13 years since Casco has been decided. And they haven't explicitly stated that there's a prohibition under KSA 44534B other than 2 years from the date of last compensation paid. And this case also is a little bit different than a straight dismissal, because following the dismissal date, I believe May 1st, the alleged date of dismissal of May 1st, 2018, on October 18th of 2018, the respondent paid to the claimant $858 for, if I wrote that down correctly, $873.87 for medical mileage and $66.97 for medical compensation, which is reimbursement for prior medical prescriptions. And I believe that that payment throws a new wrinkle into the case, because and I don't know if I'm still on.
Yes,
You
you
are.
are. Go ahead.
Okay. At that time, they paid the amount, and nothing within KSA 534B prohibits the revival of an award when compensation is paid. That was the holding in Schneider v. Lawrence, Schneider v. the City of Lawrence, and that came out, I believe, in 2019.
Did those, were the payments that were made for mileage and prescriptions that predated May 1st of 18 when the case was dismissed, or was it for things that happened after that?
The payments were for medical mileage that had accrued prior to the dismissal date, but which they weren't legally liable to pay if they had already been dismissed. If they dismissed it, then the claim is gone. They didn't need to pay that. They voluntarily paid that, and they also voluntarily paid the medic for the past due prescriptions that they hadn't paid. But if you really look at the statute, it just says compensation paid. It doesn't say new compensation. And really, it's a broadly written statute, and it goes to the exact amount. It doesn't go to any amount, and it doesn't go to when the compensation was paid. They just provided a check for the payment that was due. They weren't under a court order to pay it. They had been released from liability if we follow the judge's ruling. But I believe that this would have revived the case, just like in Schneider v. the City of Lawrence. Schneider v. the City of Lawrence would have basically states there's no limitations to revival under KSA 44534B. And that's in the caption notes on the first page of the syllabus for the court. And we believe that this is allowed because the plain language basically has no limitations as to payment of compensation. The last issue we have, which is a fairly broad issue, is whether KSA 44523F1 is constitutional in the manner that it's written. And that's our last argument on this case. But basically 44523F1, we believe doesn't meet the quid pro quo standards. They have reduced the time from 5 years to 2 years. And what happens in that period of time was, what has happened is you have a lower period of time, and they really didn't receive, the injured worker didn't receive any type of quid pro quo or anything to help them get into the 3-year period of time. And what we're asking is, was there a treating, were they able to ask for their own treating physician? Were they, because as we know, respondents can string out treating physicians, and usually they go to a conservative treating physician, as in this case, where there was a denial of medical treatment for the knees, and then you have to go to a court-ordered IME, and then the court-ordered IME says, yeah, you need 2 knee operations, and then you find another doctor to perform those knee operations. There was nothing within the changes in the law from 5 years to 3 that allows the claimants to process their case more rapidly, which would be basically being able to choose their own physicians. We believe that when applying the quid pro quo test, you need to know if there is an adequate remedy to the common law remedy that's been taken away. And making it from 5 years to 3 years basically dilutes the remedy for workers' compensation. And there is really nothing that was given to the injured worker to allow them to fulfill the 3-year statute of limitations. At this point, I don't have anything additional. If there's any questions from the court.
I don't have any more questions, and you timed that perfectly. That was exactly at the end of your 15 minutes. Okay, Mr. Estes?
May it please the court. I'm going to just sort of go through a few things that I think are important to clarify for the court's understanding today. I think the case is pretty well briefed. The issue that I see on the first point is that the time of filing of May 1st of 2015 was the time of the filing of the claimant's first application for hearing. This is how they start their claim for workers' compensation benefits.
What's your response to the argument that the department stamped it May 4th,
right,
the next business day? I mean, what is the significance of that stamp and why doesn't that control here?
Well, let me attack it kind of in reverse order the way you described it. But the reason why it doesn't control, first of all, is that 44.534B, which sets out the statute of limitations to start your claim for benefits by filing that application, also provides for fax filing in 534C1A. So it talks about the last day to take action. If you have a statute of limitations to begin your claim, if you're up against the last day, then it accounts that the last day for filing by facsimile is midnight in the division's time zone on the final day of filing. It contemplates, even in your initial statute of limitations to file, that you have up until midnight of the last day. Now, he wasn't, in this case, the claimant wasn't up against his last day to file the application for hearing, which is why the regulation 51.
You're still on.
Yeah, the regulation 5117-2 references both filing for purposes of filing something with the division, and it references service for the purposes of serving other counsel. Filing is by facsimile under C2 of 5117-2. It talks about that the facsimile filings received in the division shall be deemed filed as of the time printed on the division facsimile machine on the final page of the facsimile document received. The entire purpose of this is so that a claimant can file their application or file some other pleading, essentially, that they may need to file by a deadline. And if they get that faxed in before the day is over, it's good that day. It's going to save a claimant's claim from being timed out on a statute of limitations if they file their application on the very last day to do so. And that is consistent with civil practice in other areas. The stamp that says May 4th is the stamp that we're talking about, is on the notice of hearing from the division, notifying the employer or counsel that a hearing has been set, and that's the date of the notice. But the date of the action, to save claimants from missing their statute of limitations to commence an action, is that if you fax it in and you beat the midnight deadline, you're good. You're under the statute of limitations to commence. What happened in this case, however, was while that was all done on May 1st, it was after 5 o'clock. It was about 8 o'clock in the afternoon. That's the date of filing of the application. That then turns this case or that claim into a pending claim for benefits that under 44.523F1 has to proceed to some sort of resolution, as in the statute, a hearing, a settlement hearing or agreed award within 3 years, unless the claimant files a motion prior to the expiration of that 3 years and has good cause to extend that timeline. This court, Judge Arnold Berger wrote the opinion on Glaze, upholding that statute. The Supreme Court has upheld both Glaze and Knoll, both cases that found that failure to file your motion for extension prior to the end of that 3-year time period, you lose the time. You lose the chance to extend your statute of limitations, and the claim is dismissed. Under the statute, 44.523F1, it's dismissed with prejudice. It isn't capable of being revived if your statute of limitations to start the action still exists. You could have filed it the day after your injury. You could have filed it on the very last day before the statute of limitations to commence your action expired. But when the action is dismissed with prejudice, that's the end of it. It doesn't get revived because your original statute of limitations could have persisted or could have been extended by some means, which is why. Go ahead.
As long as I've already interrupted you in the outline you wanted to follow, is the last part of your answer also the answer to the question of why the revival argument fails for the payment of the mileage and the prescriptions, or is there more to that?
There's a little more to that. It's essentially, first of all, that once it's dismissed with prejudice, yeah, it isn't, the statute of limitations isn't revived, but I think there's two other pieces to that. The first is, if you have not filed your initial application for hearing and somebody makes a payment, that would start a new 2-year term to file that initial application for hearing to commence your claim under 44.534. However, once you've filed that action and you have commenced your claim for benefits, you're under the 3-year statute of 44.523. Filing a new application for hearing, a new payment for benefits doesn't undermine or override the 3-year statute in 523, which, if you have a new payment for claim for benefits, if you have delayed treatment from the employer's doctors, if you have good cause, this legislature provided the remedy. You file a motion for extension, you show that the claimant isn't at maximum medical improvement, or you show good cause, and you can obtain an extension of that 3 years and continue to pursue the claim.
What do you agree with Mr. Sanchez's argument that the employer or the insurance carrier in this case could have refused to pay the mileage and the prescriptions because the case had been dismissed, even though they had been incurred before the dismissal?
I don't. The first was that these were items that accrued prior to the 3-year statute expiring, prior to the motion to dismiss under 523F. These payments were also made pursuant to an agreed order, and I think it was October of 2018. The hearing on the motion to dismiss wasn't until December, and the actual order to dismiss the case with prejudice wasn't issued until January 2nd of 2019. So the case had not actually been dismissed with prejudice. It was still pending before the court or before the ALJ to make a ruling on that motion for dismissal. And those items had already accrued prior to the 3-year statute expiring in the first place. Even so, had they chosen to deny those, whether they pay them or don't pay them, could revive the statute of limitation that exists under 534. So this is similar to Schneider or the Breedlove case, that first of all, while you can revive the original action, the original claim under 534B with something new happening, a new payment. Once you've commenced your claim, the original application for hearing, you've got your 3 years, nothing revives it. And in Breedlove, even though that was an unpublished opinion, but it's attached, the court said, you can file an amended claim, which I would say is analogous to filing a brand new claim, a new application for hearing. You can file an amended application for hearing. You can have new payments or treatments. And it would make sense during the pendency of a claim that you may have payments during that 3-year time frame. You can file a new or an amended one, but your 3 years under 44.523F runs from the date of the initial application that you filed. You can't just revive it by continuing to do things later on to extend that 3 years. There are 2 different time frames. You start out in one. As soon as you file that application for hearing, you're transitioned into the other one. And the legislature certainly created a remedy if the employer's dragging their feet or not providing ample treatment or adequate treatment or timely responsiveness.
Counsel, I have a question for you. What's the quid pro quo?
Well, I think initially it's the wrong analysis. I think this is really a procedural due process issue that this court previously ruled that 523, the change to 3 years, that the requirement to file a motion for extension was not a violation of procedural due process. That was in the Glaze opinion. The Supreme Court affirmed that case, but didn't take that particular issue up on review. The quid pro quo question in my mind is what the legislature did when it changed from 5 years to 3 years, it took away, under the old statute, it was a 5-year term to get your claim to a hearing or a resolution. And if you didn't, it was a mandatory dismissal. There was no way to save your claim if you didn't make it. Essentially, that now what they did, they gave instead. Well, it's a 3-year term, and the courts and in several opinions have talked about that the purpose of the statutory change was to sort of eliminate stale claims that weren't being pursued, and by shortening it to 3 terms or 3 years in order to bring your claim to a hearing, the legislature did give back that if you file a motion for extension and you show good cause, you'll get more time. On the other hand, if a respondent or an employer recognizes or agrees that the treatment hasn't proceeded timely or for whatever reason, like any other statute of limitations, the employer can waive the defense. And
So you go from 5 years, to 3 years, but we're going to give you a way to maybe extend that for a couple of years for good cause. Is that quid pro quo, or look, we're cutting you down to 3 years. You've got to get it done within 3 years or show us good cause otherwise.
Well,
I don't see that they're getting something in exchange for the reduction.
I don't think it was, but it wasn't a reduction in any other substantive benefit or any substantive right that they can pursue to have their claim justly paid or their treatment received. It's the 3 years they have to proceed to a hearing, a agreed upon award, or a settlement hearing. It's a procedural timeline. The benefits received or available to injured workers hasn't changed. It does put a little bit of an onus on counsel to make sure they preserve that 3-year time period, or that if there isn't adequate treatment or there's any questions about the treatment, to file this motion prior to the expiration of the deadline. That no other substantive right was modified by changing the 5 years to the 3 years. Other than really, I think it gave them that it wasn't mandatory that it be dismissed upon the expiration of that time frame. I don't see it as any different than the procedural ability of any court to control its docket and impose a timeline for a litigant to get through, because under the constitutional standard, under injured workers, under Johnson, which I guess is up for argument later this week before the Supreme Court, it didn't change any substantive right to benefits to claimants to make that 5-year change to a 3-year change. They both were essentially an ability or a rule to try to control the docket and get these cases through to a hearing, to an award, and conclude it. I will say, I just point out then that if your honors don't have any other questions, that I think that on the dismissal with prejudice from a strictly procedural standpoint, that the court has addressed this, both the Court of Appeals and the Supreme Court have addressed this, and the precedent I think is pretty clear that if the motion is not filed prior to the expiration of those three years, that the claim must be dismissed, and per the statute, it must be dismissed with prejudice. That was, although unpublished in the Breedlove case, something that I think is analogous. The court concluded you can't bring that back. You have to meet that 3-year time frame. Although that was under the old statute. The other side of this is, I see this as the way the Glaze Court, the Court of Appeals analyzed this in Glaze, is accurate, that this is a procedural due process concern. Did you have an opportunity for a hearing? And in this instance, the claimant had the opportunity for the hearing. If the claimant believed that they were not receiving the treatment they should have been receiving in a timely way, the legislature provided for a remedy, which was to file the motion for extension, which wasn't done in this case. And on those two bases, I think it should be affirmed.
Thank you. Mr. Sanchez, your 2 minutes.
Yes, Your Honors. Just in rebuttal, I believe the argument that KSA, that the last date of filing for an application for hearing, either that can go to the last date of hearing, or the last date of filing would have been, there wasn't no time pressure within the 2 years of statute of limitations. And clearly in the legal community, there's no filings on Saturdays and Sundays. If we follow the regulations as written by the Kansas Division of Workers' Compensation, it would have been moved to the next day, which would have been May 5th, which is captioned, or May 4th, 2015, which is captioned on the notices sent to the parties. I believe that this case is different than Glaze, as Glaze definitely states, and I state in my brief, that Glaze goes to an opportunity to be heard. It doesn't discuss quid pro quo. I have nothing further, Your Honor.
Okay, thank you. We will take this matter under advisement and get a decision out as quickly as possible.
Thank you, Your Honor.
Thank you.